program continues today with a session hosted by IPOS Mediation entitled Settling Disputes Outside of Court, Risk Management for Business. Before we get into the session, we have one quick housekeeping note. We encourage as much interactivity as possible, so if you have any questions for the panelists, please use the Q&A tab at the bottom of your screen to submit. Now back to the program. It's time to introduce our moderator, Henrietta Jackson Stopps, partner and mediator, IPOS Mediation. Henrietta, the virtual stage is yours.
Thank you very much, and thank you everyone for joining us this afternoon. For those of you who don't know us, IPOS Mediation is a panel of 32 mediators with a broad range of experience and skills. We've been in the business of providing experienced and effective mediators to the commercial litigation market for over 25 years, and I believe we've mediated close to 20,000 cases between us. I'm delighted to be moderating this conversation today about why in-house counsel decide not to take their disputes to litigation and choose arbitration or mediation instead. Of course, you all know that arbitration and mediation are uncomfortable bedfellows, joined together under the title of ADR. They really are very different processes, a point that I hope will come into our discussions today. We have a fabulous panel. We've got Emma Emery from Capita, General Litigation Counsel there, Simon Bourne, Associate General Counsel at PRS Music, Fiona Meany, Global Litigation Director at JLL, Helen Barrett-Haig, General Counsel and Chief Risk Officer at Doncaster's Group, and Rebecca Clark, a former in-house lawyer at a bad bank and now a full-time mediator. And sorry, Tara, I've forgotten you. Tara Potter from Hexel. Sorry, our panel's so big, I've forgotten, bound to leave somebody off. I think we'll jump straight into the discussion. And please do put any questions you might have in the chat. We'd really love to hear from you. Just so we can get a quick idea of your collective experience, our audience's experience, I'm just launching a poll now, which I'd be really grateful if you could answer. Just so who we know, get an idea of who we are talking to. While that's going on, we're going to start with the question of why do you choose not to litigate, and what factors do you take into account as to whether you mediate or arbitrate? I'm going to start, Emma, with you. So why is it that you don't decide not to litigate?
There's a number of factors really as to why we wouldn't litigate. I mean, the obvious are time, cost and risk. It takes a lot of our time internally, even if we've got external lawyers instructed to help us. And the cost is quite often disproportionate, unknown, open-ended. And just from a finance perspective and a financial reporting perspective, that's not something that's very appealing to us. And there's a risk we won't succeed. Just on the financial reporting point as well, we have, where we have disputes, we have to make provision for claims in our financial accounts. And ideally, we don't want those provisions sitting on our books for longer than we need to. So mediation, for example, which is our general go-to, is much quicker at getting a dispute resolved and then off our books. And the other reason, key reason actually, is that we have a lot of long-term relational contracts with our clients. So whilst we might be in dispute with them, it might be an in-contract dispute. Litigation is obviously quite a lot more contentious than a method of ADR. So that's another reason why it's quite appealing to us.
Thank you. I know that Simon, you have a different avenue for resolving your disputes, and that mostly is arbitration is your thing. What are your reasons?
Thanks, Henrietta. I mean, I probably need to tell you a bit about our business in order to answer the question, really. So, as you mentioned, I work for an organisation in the music industry called PRS for Music. We're a membership organisation that's made up of around 150,000 songwriters, composers and music publisher members. And we exist to license their copyright in music and lyrics where it's put to commercial use. and then we collect the royalties under those licenses and distribute them out to our members in accordance with usage information that we receive and our distribution policies. We have licensees that include big broadcasters and digital services like the BBC, Sky, Spotify, Netflix, TikTok, etc., through to licensing the live performance of music, so big concert venues like Wembley and the O2, all the way through to other public performance of music in commercial premises, so nightclubs, although not many of those open at the moment, pubs, restaurants, hotels, etc., and then retail premises and everything in between. So a vast amount of licensing goes on. Some of that's carried out through our joint ventures and with other music industry organisations. We've partnered up with a number of organisations with a view to reducing cost and streamlining and creating efficiencies for the market. But as you might imagine, we and our joint ventures sometimes get into disputes with licensees over what the appropriate royalty should be. And under copyright legislation in the UK, licensing bodies like PRS are subject to the regulation of a specialist tribunal called the Copyright Tribunal. And that tribunal has jurisdiction to hear disputes over the terms of a license that PRS has granted or is offering. And it can make an order against PRS and to bind the parties to the proceedings that varies the term of the license to what it sees as reasonable. So if we at PRS are going to litigate a dispute with a licensee over the terms of a license going forwards, then it's the Copyright Tribunal that's the forum for that. However, the Copyright Tribunal only has jurisdiction over UK acts of licensing, so acts involving UK copyright. Now, as you can imagine, technology and market developments have meant that the industry's moved forwards in such a way that we now often license on a multi-territory basis, particularly for the digital music services like your Spotify's and Apple Music and YouTube and so on. So we therefore face a scenario where litigation can't offer us a satisfactory option for the resolution of multi-territory licensing disputes, and we've had to turn to other methods like arbitration. So the great thing about arbitration is its flexibility as an ADR process, and you can design the ideal procedure for resolving the types of disputes that are faced by your organisation. Now, we have come up with a pre-pack arbitration process that is very much based on the UK Copyright Tribunal process, but it does have that multi-territory jurisdiction that we don't get in the UK Copyright Tribunal. Now, of course, it needs to be a balanced procedure in order to reach an agreement with an opposing party. Unlike litigation, you can't force someone into arbitration unless you have a binding arbitration clause in a contract between the parties. And in our licensing disputes, we don't have that binding arbitration clause. So as I say, we've developed this pre-pack arbitration procedure, which we feel is a very balanced procedure to both parties. We're particularly keen to use it with our multi-territory digital music services that we license. And we had the first run of that procedure last year with TikTok, and a settlement and a license was agreed through the use of that procedure. But we do really expect that this form of arbitration process will now become the norm for resolving our pretty specialist disputes over multi-territory licenses as an alternative to litigating in the Copyright Tribunal.
Really interesting. Do you have pushback from the opposing party on using a process that you've designed?
Yes, and we have had that pushback already, and we've had other forms of ADR that look probably cheaper and quicker in theory that have been proposed, because arbitration, it isn't the cheap option. It's very similar in formality and length and procedure to litigation. We have tried to create a procedure that is as streamlined as possible, and we think it would run its course quicker than the Copyright Tribunal proceedings would. But we do still get that pushback, and I think it's just natural for people to be suspicious that if one of the parties is proposing something, that you expect it's going to favour that party. But as I say, we have really come up with this as a pre-pack procedure that we feel is balanced, but we are open to negotiation on that agreement, and we can take into account any specific requests of the other party.
And are you looking at a 3-person or a single arbitrator?
So our pre-pack agreement does propose a 3-party arbitration panel.
Yeah.
And the thinking there was that you're less likely to come to a surprise and an unwanted decision if you have that sort of greater level of checks and balance between the panel.
Yeah, agreed. And I presume makes it easier to get the other side to agree to the arbitrator.
Yeah.
Yeah. Really interesting. Thank you. Tara, what's your experience? What type of disputes are you facing, and what do you do with them?
So I'm in a completely different industry. So what Hexcel do is advanced composite technology manufacturing. So super strong, super lightweight material, or like carbon fiber and things like that. We operate predominantly in the aerospace market. So like Emma was saying, we have really long-term relationships. And so that's why in our contracts, because of the complexity and because of wanting to maintain those relationships, and because a lot of the information that's going to come out is going to be confidential, it's sticking to an arbitration that is likely to protect a lot of that information and isn't like a public dogfight, right? Because that's what everybody wants to avoid having. In the same time, like Simon just said, is when ADR was first being really pushed, right? And I remember it was really being pushed when I was a trainee. From that time, or maybe I was just aware of it going forward, everybody talked about, how it was going to be cheaper and how arbitration was going to be faster and all these things. And that has not been aligned to my experiences at all with arbitration. Saying that, it does still have some really good mechanisms, like the ability to narrow the focus, to only, share certain information, to narrow down the complexity of the matter, just in terms of what information is being disclosed and shared, and narrowing the number of experts and things like that. So on balance between arbitration and litigation, as Simon says, I think you're paying the same amount of money, but it does still have some good sides to it. And I do actually just want to also cover off mediation, because although I can flip-flop on how I feel about arbitration, I think mediation in sort of a contractually bound mediation is incredibly useful. I find those sort of escalation clauses to be critical in solving disputes, especially where you have these, our contracts last 15, 25 years, they're very long. So where you can escalate to mediation without losing face, without, giving an indication that somehow, your case is weaker or anything like that, but where you can rely on the contractual mechanism, I find it to be incredibly valuable as a process to engage in.
Really interesting. Do you find that the parties, having written mediation into a multi-tiered escalation clause, then still want to mediate?
I think generally, yes. I think where there's issues is where you have that sort of multi-tier, and somewhere there's some sort of ambiguous language that says that, managers or executives of sufficient, I don't know, gravitas and seriousness and whatever must meet to do it first. I mean, I feel like that's a bit fluffy. So that's not necessarily needed, but actually a requirement to mediate. The parties might make noise about it, sort of positioning to be like, oh, fine, we don't think we're going to resolve it. But ultimately, even if you can go to mediation and knock out a couple of issues, you don't have to come to a complete settlement on it. You are going to be in a better position to later try to solve the dispute. So I found it to be useful. And I think the parties do, worst case that happens is you spend a day doing something that isn't ultimately getting over the line, but it shows good faith, and I think it does open up a dialogue that ultimately is very useful.
Interesting, thank you. I was just wondering, Emma, just coming back to you on the issue of the clauses. Do you write mediation clauses or arbitration clauses into your contracts?
Yeah, I was just going to come in on that anyway. We're quite often, we have a lot of public sector contracts, so we don't have a lot of control over the content of those, but we have escalation, we have a dispute resolution suite of clauses where we'll have escalation level meetings, and then it's quite often an option to mediate and not a requirement. I'd much prefer it to be a requirement in some cases, because sometimes actually in our public sector contracts, you'll find that it's in the hands of the contracting authority as to whether they will agree or not to mediation. So it will be the authority may elect to mediate or have an expert determination in advance of either adjudication or litigation. But the escalation clauses are really useful, especially in long-term relational contracts where you want to escalate an issue, but you don't want to have to start writing letters of claim and litigating straight away. It's putting a marker down that actually we're getting serious now in this dispute. But you can do it in a gradual, staged way, whilst trying to maintain a relationship and continue to deliver your contract.
Yeah, really interesting. Thank you. Helen, what type of disputes are you dealing with, and what's your approach? And how do you get business on board with the decision to mediate or arbitrate, if that's the route you decide to go down?
Well, I think as Emma and Tara both said, certainly mediation tends to be cheaper and faster than litigation. What I think the board really like about it is that you can have people from the business involved in a mediation and to some extent an arbitration that actually understand how, say, the problem arose, and they feel empowered to be part of that process in a way that perhaps they don't feel so empowered to be part of a formal litigation process. What they're also quite pleased about, I think, is when you describe to them that you can come up with some flexible solutions that perhaps, you know, sort of suit both parties, and also, as Emma pointed out, allows both parties to continue to work together in the future. Where I think that perhaps boards are more concerned about going down an alternative dispute resolution process is around the unpredictability that you might get and in any decision making, and also that certainly involved in a, you know, if you're involved in a binding arbitration, that they don't subsequently have the recourse to go to litigation if all else fails.
Yeah, I can understand that. Fiona, is that your experience? What's your experience in terms of persuading business to and other stakeholders to mediate or arbitrate?
Yes, coming at it from a more of a mediation standpoint, which I think shared with Helen and Emma and Tara in terms of approach. In my experience, business people who've been involved in a dispute in the past are extremely keen to pursue alternatives to formal litigation. They've gone through the process, they've had that experience, and they're generally very supportive of ADR in principle. One thing I do find on occasion, certainly across the business, that when I'm speaking to stakeholders, is that you have to make sure you don't overestimate how much they know about these processes. So a lot of business people may be aware of the term mediation, they understand it as a concept, but they're not clear as to what actually happens on the day. How will this help us get to a resolution? So for me, the approach I take is to really try and focus on educating them about the benefits from quite an early stage. So at the point when we're identifying our response to a claim, when we're setting our litigation strategy, it's a familiarization piece, and it's designed to build engagement and support. So particularly speaking to mediation, I think we're all aware of the key advantages from a legal perspective, but I think that the message I find that really lands is to explain to our teams that this is a process which has the potential to reduce risk, it will save our people's time, and potentially it's going to save our company an awful lot of money as well. And that's a message that once you've crystallized that within the minds of the business people, they can get on board with, and you can then talk them through what a mediation actually might look like on the day, bearing in mind the point I think Helen made around flexibility.
Yeah. And thank you, Fiona. And Rebecca, I know that you've had experience in-house and using mediation in-house and are now a mediator. And what do you think of what were the key things that you used to persuade your stakeholders when you were in-house?
Yeah, it was interesting when I arrived at the bank, because it wasn't fundamentally that keen on mediation. It wasn't keen on arbitration at all. But the issue they had with mediation was the need to compromise. And they very much saw that as a kind of weakness, and that may be reflective of the fact that I was working at a so-called bad bank. So this was recovering monies for the taxpayers. So there was an element to which they felt they had to get all the money in that they could and not compromise. But so the way that I kind of sold it and managed to integrate it into our litigation practice was to really focus on the ability for mediation to control risk. So the legal department was part of the risk function at the bank. And historically, there'd been a lot of frustration about the inability to forecast properly because there were claims brought by the bank and claims against the bank. And people found it very difficult to report and forecast and report up. So, but by focusing on risk, you can have a really nuanced approach to each case. So you can apply different factors, different risk factors. You can almost do possibly a slightly artificial, but a mathematical calculation that you can go to a mediation with, that actually, if you're taking instructions from a risk department, is really quite appealing to them because it gives them some structure and gives them the feeling that they've got some control over this massive asset pool, because that's fundamentally what it is. It's a huge asset pool, and they felt they had no control over what was going on with it.
Thank you. I mean, I think that question about risk is a really interesting one, and certainly I think we all talk about, or have in the past talked about, mediation as always about settlement, but actually people come to mediation should be thinking of it of a risk analysis, a way of finding out information that they might not know, and then if they're in the right place, they can then make a decision. But settlement doesn't necessarily have to be the end of the process. We're going to move on to talking about what you might be looking for if you use external counsel for your mediations or arbitrations, and what you might look for in terms of support from them. Emma, starting with you, do you use external counsel? What do you look for from them when you're mediating or arbitrating?
Because we have quite a strong litigation team in-house in Capita, we tend to do most mediations ourselves, unless it's so hugely complex and unwieldy that it's capacity-wise we can't deal with it. And we're all experienced litigators in the team. So if we do engage external counsel, it's a capacity issue, or it's to provide some expertise that we just don't have amongst us. Quite often we will deal with the mediation ourselves, but if there's a particular issue that will help unlock the dispute that might be worth getting some external advice on, then we will do that. But in terms of the preparation for mediations, we do most of that ourselves. I think in terms of what we look for when we do engage external counsel, for me, commerciality and control of costs is paramount. I have a real issue with the control of costs issue and cost budgeting, and actually tracking it as well. We work on, our organisation works on major projects which are budgeted and costed in advance of delivery to the penny, and so our internal stakeholders struggle to understand why on a litigation project, which probably is not anywhere near the size of those kind of projects, it can't be costed finitely or definitively and tracked properly. So for me, it's a commercial awareness around those kind of internal stakeholder issues that we have that's really important. And you know, there are some firms we use who are really good at that, and some who are really bad at that. And you know, quite often we might lean towards the firms that are good at that, as well as having the expertise we need. So that's a really important thing for me. And also just a firm that will bring new ideas to the table. When you're mediating, you've got to be creative about how you might resolve a dispute. It's not just about the money. What else can we bring in that might get a deal across the line? And the commercial awareness of the external lawyers, coupled with the expertise that they may have in that particular area, is something we look for. So if we've worked with people who've demonstrated that for us before, then they're going to be our go-tos, I think.
It reminds me of something I heard what an in-house counsel say the other day about the difference between, you know, in-house counsel being in the business of relationships and external counsel being in the business of disputes. And the good external counsel realizes that and realizes that tension. Tara, what are your views on external counsel and what they can do for you in arbitrations and or mediations?
So we have a much smaller team over with Hexcel. So we would normally handle the early side of anything in terms of arbitration or mediation just ourselves. And then at some point along the way, because of capacity and resources, we would go to externals. Also, we would probably do so because there's usually an international element to our contract. So we'll have, besides contract documents, you'll have questions that are going to come up in various different jurisdictions. So it's worth it, even if we're relatively certain on the way forward and how we want to manage it and sort of the strategic approach, be comfortable with that. But just sort of from a belt and braces sort of perspective, we would go and get external advice and go to our panels for that. We do have 2 external panels that we engage with, and those have been, the panels have generally been selected for those reasons that actually Helen had mentioned in terms of flexible solutions coming out of mediation, and Emma just did, you know, are you giving us strategic options? Are you actually thinking commercially? And what I'm getting from my external counsel, is it going, and I hate these now, formal legal advice? Like if I need formal legal advice, okay, but let's go to a barrister to get it. And then let's go back to what's actually reasonable and proportionate and is going to get us over the line, because costs are a major influence on this. And the longer it goes on, when there is a commercial solution that exists, makes the external law firms obviously much richer and much happier, but we don't actually get anything out of from just a commercial and relationship perspective. So you want people who are also not only going to be able, from an external point perspective, also not only going to be able to tell you the law and bring in people from other jurisdictions to sort of tack on to what you're doing, but who you can put into a room with your CEO or your CFO or with whomever, and also have a conversation at a really basic level that doesn't like sort of go to legal. It is still really solution oriented. So that's what we look for overall. You're muted.
Oh, I knew I'd do that at least once.
Somebody was going to do it. It was you.
I get the wooden spoon. Simon, what are your views on external counsel? Do you use them for your arbitrations?
Yeah, so for those arbitrations that I was talking about earlier, we do look to external counsel in a similar way to the way we would for litigation. So that's for expertise on the formal procedure, including advising on and drafting those arbitration agreements at the outset, but then also running the proceedings, the correspondence, the preparation of pleadings, the evidence, the interim applications, etc. So it's very similar to the litigation process, and we use external counsel for our litigation as well. So we'll of course provide expertise on the licensing side. So there's factual evidence, there's economic expert evidence that we'll feed into. We'll put forward those witnesses of fact for cross-examination, etc. And if there's ongoing without prejudice discussions alongside the formal proceedings, then we'll run that dialogue and we'll constantly be looking for ways to close the commercial gap between the parties. So that's our job. Ultimately, I think, as others have said, we nearly always hope that our cases will settle without the need for a decision to be made, or without the need to get through whatever process it is you've started. So we're looking for external counsel to be extremely commercial and to understand the commercial positions that are being exchanged, and possibly to engineer opportunities for settlement, to identify the best times tactically for us to be making those without prejudice proposals, and to advise us on how those proposals look in comparison to the likely outcome if the formal process is followed. So I guess that's what we're looking for in terms of the advice and the support. But as Emma mentioned, costs is the other thing that I think is worth just emphasizing. Arbitrations, as I said earlier, they're not cheap. They're generally not lower in cost than litigation. And we really look to our external lawyers to innovate with us on finding ways to structure the costs. We want as much certainty as possible in order just to allow for effective budgeting. And so we'll always expect costs to be capped at the very least in order to prevent them spiraling out of control. And that obviously can easily happen in litigation and arbitration. We've also agreed fixed cost arrangements on a number of substantial pieces of litigation and arbitration. And we've been exploring some interesting shared investment models like CFAs, where we receive a discount or pay no fee from a certain stage of the proceedings in the event that the case isn't successful, but we pay an uplift on the fees in the event of a success, so a success fee ultimately. And we want to work with external lawyers who are open to those sorts of ideas of breaking the mold. Gone are the days for us of just paying these sorts of things on a time cost basis.
That's really interesting, and to hear of the conversations that you're having with your external counsel. I think that is probably where the future is going, and I'd be interested to see how that plays out. I'm highly aware of time, and moving on to sort of preparation for mediation or arbitration. Fiona, what are your top tips for preparing for mediation, both your in-house team and your stakeholders, of course?
Yeah, if I just run through some top tips, I'd say do your homework when it comes to mediators. Select a mediator with the right skill set for your case. That might be a technical skill, it might be a soft skill. If you have a particular counterparty who needs a certain style of management, ensure you have the right team in the room. It seems obvious, but you really need to spend time, make sure you have the right people, they know their roles, you've got the appropriate authority, you know how to obtain more authority if needed, because as we all know, quite often you get pushed slightly further than you might want to be, and the other side gets pushed slightly lower than they want to be, and that's where you reach a settlement. Prepare your own risk assessment. Do your best and worst case scenarios for the claim. Don't forget your litigation costs. Test it in advance. Identify your range. Know your basis for that range, and spend time assessing the other side's drivers. This is something Emma mentioned. They might not purely be financial, so what else can you do? What else can you bring to the table to get this deal over the line? But the absolute key piece of advice I would give is to know your story. So you can know everything about the legal arguments, you can know all of the facts, but if that information doesn't coalesce around a clear and coherent position, then you're going to struggle on the day. And I think if you spend time, put the time into knowing your story as in-house counsel, being able to succinctly articulate what your position is in a sentence or two, that then feeds into every strategic decision you make. It feeds into every discussion you have with the other side, with the mediator, etc. So you have this as your central kind of totem pole, really, and everything else builds around it on the day.
I think that's music to a mediator's ears. I wish that every client came in so with that knowledge. Fiona, Helen, what tips do you have? Anything to add to that?
Well, I would absolutely echo what Fiona has said, and I'd go as far as to try and almost prepare the other party's case, because I think when you sort of stand in the other party's shoes, you start to see not only the holes in your own position, but also what might drive them to a settlement other than just a financial one, for example. And then getting that authority and that approval for a variety of different commercial solutions, because in my experience, you don't really know on the day which way things will go. And the other party might already have come with a bit of a plan on how they would like to settle it. So you need to sort of think outside the box. You need to get those approvals in advance, or as Fiona says, know how to get them on the day. Also, I think you need to involve the right people from the business. You can school them to a greater extent than you could do if they were going to be a witness in a court of law. and be clear with your people who's going to address what, and be close enough to them to sort of metaphorically kick them under the table in the event that they're going down a line which perhaps is a little unhelpful. And you know, I think tell them up front that you're there to help, you're there to not pull the wool over anybody's eyes, but just make sure that people put their case in the best possible way. And also, I found on occasions that business people can be quite emotional about things when it goes wrong. And as part of your prep, try and take the emotion out of it so that people can be constructive on the day to kind of come up with a solution.
Mm-hmm. Brilliant pieces of advice. Rebecca, as the mediator, what do you like to see, or what did you do when you were still practicing as a lawyer?
I think probably the best piece of advice I could give is that you need to do what you can to ensure that your counterparty is properly prepared. Speaking to many of my colleagues and in my own experience, when a mediation doesn't work, it's often because the people sat in the other room have not done their preparation properly. So maybe they don't have the right mandate, or they haven't got the right person in the room. And so it's almost, the more you can spoon feed their preparation to them, the more you're potentially going to get out of it. I think that's my piece of advice. And to the extent, for example, when I was at the bank, our mandate structure was crazily clunky, and I don't think anybody else would have quite this level of time. But if I had a very big mediation and I had to get board approval for a mandate, then I would have to do a mandate, prepare a mandate paper for board, which had to be submitted a month in advance, which then had to have gone through the risk director and the various committees weeks before that. So I had very little flexibility in the run up to the mediation to alter my assessment of the risks and get a new mandate. So if I was presented with a load of new information the day before the mediation, which can sometimes happen, or people think, oh, I know, I'll just drop this in because it's a really killer point and I'll make it in my opening statement. That's too late for me because there's nothing I can do with that. So it's knowing who your opponent is and what you need to do to make sure they have the right mandate there on the day. Because aside from that as well, even if your mandate process isn't that clunky, actually, as humans, we need time to process new information that we're given as well. We have a mixed response to information because we like new information because it's how we've evolved as a species, but we also don't like it because it contradicts what we think, and that causes some conflict. And sometimes we need time to process it and work out how that adjusts our thinking, and it can just be too much in one day. So it's about managing information and making sure you've given as much as you can to the other side so that they can engage with you properly on the day. Really useful points of advice. I'm highly aware that our time is about to run out, and we did have one question about the uptake of arbitration by financial institutions. I don't think we've got nearly every industry on this panel, but financial institutions aren't quite there, although I don't know whether, Rebecca, you've got anything to say about that. Yes, I mean, my experience is 5 years out of date. So with that caveat, what I would say is we were huge fans of mediation. We had several arbitrations, and I would say they were not particularly successful in terms of costs running away. I found that the arbitrators were not as cost aware, perhaps, or on top of costs as much as a court is, and that was unhelpful for us. And there seemed to be less drive and less urgency with an arbitration. Now, that just might be our experience in our panel, and I'm not, I don't want to speak widely about everything, but I think for us as a financial institution, we preferred litigation, which was predictable with set rules and well, maybe not predictable because you always get some random decisions, but more predictable maybe, or mediation. But I don't know if other people felt the same.
Yeah. I mean, one thing I wonder about is whether there is anything that any of your internal clients say about the enforceability of mediation, and whether they balk at the fact that they don't feel that a settlement agreement is as enforceable as an award or a judgment, because the Singapore Convention on Mediation is present and the UK are thinking about signing up to it. Do any of you come across that issue when rooting for mediation?
No, we don't.
No. Because I have previously heard that, you know, that's why businesses might fear it or doubt it. I must say that as mediators, we very rarely see, and perhaps it's because we're no longer part of the process, but we very rarely hear of issues about enforceability. But I have heard that from perhaps the uninitiated businesses. I think in drawing this together, there are 3 C's that appear to me to be the themes that have come out of today's discussion. Control being one of them, keeping control of your dispute, whether that's by, in Simon's case, arbitration and creating a process that works for his industry, or whether that's by mediation, being able to control the solution that comes out of it. Cost is obviously a factor, and that links into control, of course, control of costs and parties, businesses wanting to control that cost of litigation, and the 3rd C is commerciality. It really is, especially in those where the disputes are with long-term business parties. It's really clear that commerciality is a big driving factor in the choice of dispute resolution method. And of course, going to court, we create winners and losers. And in mediation, and less so in arbitration, there is a middle way, perhaps. So I just want to say thank you to you all for joining us. Thank you for your really useful and interesting insights. Yeah, I look forward to seeing you soon. Thank you to the audience for joining us. And I'm going to hand back to our event host. Thank you.
Excellent. Thank you to our wonderful panel for a fantastic session. Up next, we have a networking break and marketing brief sessions. Be sure to head over to the Market Brief tab to view all the discussions that are taking place. Additionally, feel free to connect with colleagues and industry experts through the networking directory page. Thank you again to our panel, and thank you for joining us at Dispute Resolution Forum 2021.